What is up, everybody? Justice is a process here, and I want to jump in here really quick, and I wanted to drop a video in here because one thing that I've seen a lot discussed in the comments and during the trial watching, and that is trying to understand why Alicia Andrews is charged. And there's a lot of I've seen discussion going back and forth. You know, she's guilty of conspiracy, but not of first degree, and I think a lot of people are confused as to how the state's theory is working. And given that tomorrow it looks like this case goes to the jury, one way or another, the judge is giving the case to the jury tomorrow, and will, I'm certain, let the jury deliberate in as late as they need to, because I think she wants to resolve this case as soon as possible. But the way this case is being prosecuted is something known as the Florida principle theory, and I'm going to go over that legal framework with you, discuss it with you, let you understand it so you're well equipped going in tomorrow to closing arguments. So let's jump in real quick here and go through this. It's going to be a quick video to be able to explain this to you. So here it is. So this is a little document here. If you're a member, it's in your member folder under special documents and presentations, so you can have access to this and be able to see it and have it for you as you're going through something you're going to hear when the jury instructions are going on. But Florida principle theory, what is principle theory? Principle theory is, under Florida law, a person can be convicted of red rum even if they didn't pull the trigger, didn't physically harm the victim, and weren't even present when the killing occurred. This is called principal liability, or the principle theory. One of the very first cases I ever covered on this channel, the Franklin Tyrone Tucker, my good friend there, Franklin Tyrone Tucker, he was being prosecuted under the principle theory. And the idea behind the principle theory is that, well, we're going to get into it. So, Florida Statute 777.011, the principle theory is defined as such: whoever commits any criminal offense against the state, whether a felony or a misdemeanor, or aids, abets, counsels, hires, or otherwise procures such offense to be committed, is a principal in the first degree and may be charged, convicted, and punished as such, whether he or she is or is not actually or constructively present at the commission of such an offense. In plain English, what does this mean? This is the confusion. If you help plan a red rum, provide assistance, encourage it, or do anything to make it happen, you are just as guilty as the person who actually pulled the trigger in Florida. The law treats you as a principal to the crime. Think of it as this: the guy who pulls the trigger is the principal, and you will be treated as if you are the principal. And that is a really scary thought, because and this is how others are going to get charged. We heard today Young and Ace, not Young and Ace, J. Dot, Breezy, being discussed during Detective Ramos' testimony today, and they asked the question, hey, he hasn't been charged yet. He said, not yet, because we learned that J. Dot is alleged to have sent $390 for the deposit for the Airbnb. And an act, as you're going to find out, as small as that, can actually be used to charge someone as a principal in the death of Julio Foolio. So we're going to go over it. It's not as simple as it sounds, but it's simple. And in this case, you're going to see and you're going to understand what you need to focus on as you're evaluating this case and you're hearing the closing arguments. So let's get into it. There are three elements that the state must prove to convict someone under the principle theory. The prosecution must prove beyond a reasonable doubt. And remember, it's beyond a reasonable doubt. And a reasonable doubt means if there is a reasonable explanation, and she is presumed innocent. So remember, if there are two standing theories and one is reasonable as the other, in other words, there's a reasonable explanation of guilt, there's a reasonable explanation of innocence. Because the presumption of innocence exists, the law states you are to settle that dispute if the state doesn't eliminate the innocent explanation, then you are to find the defendant not guilty. The law does not require the defendant to make a standing proof of anything. All they have to do is raise the possibility. And that is what her defense has been doing the entire trial. They just have to say, this is possible, and that a reasonable person could explain this in this way. The state must eliminate all of those reasonable possibilities to for these three elements. And if there is anything standing up that says it could be explained this way, this is a reasonable explanation, then not guilty is what must happen in this case. And this is what the defense is driving at. The state, and this is why this case is a little more difficult than what you might think, because, well, we're gonna get through it. I think it'll become abundantly clear as you go through. The first element is knowledge. The defendant knew a crime was going to be committed or was being committed. Now, that is not mere suspicion and not should have known, but actual knowledge is required. And in this case, this is very important because the defense has said that Alicia Andrews was there as a girlfriend. She was there believing that this was a weekend getaway with her boyfriend. And her mere presence in the car, her mere presence is not enough. Even if she knew her boyfriend was about to do something, you know, or thought he was going to do something, she had to have known that this was a specific purpose for, and that the crime was happening, and that this was not something that she thought could be happening or might be happening, but she had to know it was happening and that this was what was happening. And then there has to be intent. The defendant had the conscious intent for the crime to occur. So she had to have intended for this to happen. So if the state doesn't prove that she intended for this to happen, then she must be found not guilty. They have to prove that she wanted it to happen or helped make it happen, not just being present. So her being, let's say she knew it was going to happen, but she never intended for it to happen. In other words, she heard discussion of it. She doesn't have to get in the way and stop it. She doesn't have to call 911. That doesn't make her guilty under the theory. She has to have intended for this to have occurred, and then you're going to find out the third component. So she has to have had knowledge. Hey, tonight they're going out, or this weekend, the purpose of this trip is to go down and kill Julio Foolio. She has to have intended that for Julio Foolio to have died. Now, think back to the text messages that we heard about, and you're going to see why all these things are coming in, why they're bringing up the guns and the things that were present. That is the knowledge. The text message shows her intent. Now we have an action in furtherance. The defendant must have performed some act that aided, abetted, counseled, hired, or procured the crime. Now, in the case of JDOT, the act would be simply providing the money and paying the deposit. But then you have to come back up to, he had to have had knowledge that a crime was going to occur, and he had to have intended that money was meant for that crime to happen. If those three things can be proven beyond a reasonable doubt, meaning there's no other explanation for them other than guilt, then he can be charged as, under the principal theory, with first degree, red rum, and he can be found guilty. And he can go to prison, and he can get the death penalty, and he can be treated exactly as the trigger person could be. Now, examples of acts in furtherance. So keep this in mind. Providing transportation to and from the crime scene. So if she provided a vehicle, if she was the driver and she was driving there, and she was driving with the express intent, with the knowledge that the crime was going to occur, intending for it to occur, then the driving is the act in furtherance. Providing weapons or tools, same test. Was she intending it? Did she have knowledge of it? If they say yes, acting as a lookout, knowledge, intending it to have happened, she was a lookout. That is an act in furtherance. Providing information about the victim's location. If she sent any of those text messages, or if she provided information. Now, if she just told her boyfriend, oh, I saw Julio Foolio is going to be at this club tonight, but there was no intent for him to get killed, there was no intent for a crime to occur, that doesn't count. She's not guilty. They have to prove that what she was doing came with the intent and the knowledge of this crime happening, and then that act is considered in furtherance. Coordinating timing or logistics, disposing of any evidence, providing alibi or false information to the police. So if she was doing that, providing an alibi for somebody, then that can be considered to be in furtherance of the crime. The act doesn't have to be essential to the crime's success. So it doesn't even have to have been something that says, well, that piece of evidence could have been nothing at all. This is the dangerous part. Let's just say, and we heard this under the principal theory, that was the mom that was charged under her son, that she was came into the state of Florida and her son shot his girlfriend. She provided the information to her son. She's a principal then to the crime of killing. And that's how she was convicted. Okay? Now, it doesn't have to even be good information. She just says, here it is. But if it ends up happening, even if it didn't contribute, because maybe it was the wrong location, but if when she provided the information, she intended for this crime to happen, and she knew it was going to happen, and she gave the information, and that person goes to the wrong spot, and eventually sees the person across the street, goes, oh, there you are, boom. But if it can be proven that that was given with the knowledge and the intent, and that's the act, you are guilty of first-degree red rum. Now, let's go over to critical distinctions that you must be considering as you're watching and learning about this information. Mere presence is not enough. What does that mean? Just being there when a crime happens doesn't make you guilty. You could be an unwitting passenger, an innocent bystander, or someone who didn't know what was happening. That's what a defense is alleging. But the defense doesn't have to prove that that was the case. The defense only has to raise that as possible, and the state must disprove it beyond a reasonable doubt. Mere knowledge is not enough. Even if you know a crime is going to happen, if you don't intend for it to occur and don't do anything to help, you're not a principal. Though you might have had a duty to report in some circumstances, it doesn't make you a principal. That can be dealt with separately. The act can be small. The act in furtherance doesn't have to be dramatic, like driving a car, making a phone call, tracking the victim's location. In this case, that's what they're saying the action was. She's seen at McDonald's. She's tracking him down. If she was helping in any way, if her presence in the car was to help, but the state must show what the act was. Now, if she's just merely present because she's there with her boyfriend and her boyfriend is tracking him and she's unaware and she's on her phone, the reason why the cell phone expert was brought in today is because what they're trying to show is that she's active on her phone doing things unrelated. She's just there. She's not there tracking. She's there checking out her socials and doing all that stuff. That's what that purpose is. If they raise that, the state must eliminate that and say, okay, beyond a reasonable doubt, you've got to believe she was present there with the knowledge, the intent, and then that is the furthering act. But then you got to define what that furthering act is, and that's where the state is struggling in this case to really say, well, what was it? They're like, well, she was here this, she was present this, but here's the problem. So was Chance. So and since the defense has said this is asserting that, hey, she was there as a girlfriend, they've got to disprove it. What the defense is going to do is they're going to stand up tomorrow and they're going to say they can't disprove it. They can't disprove it beyond a reasonable doubt, and you must return a verdict of not guilty. Now, because the judges allowed so much of this stuff in about the weapons and all these things and the text messages, the state's going to basically say, listen, your triers of fact, you can infer from that evidence what you want. You can find from that evidence what you want. And if you find that evidence shows knowledge, shows intent, and then shows that she's present in the car with the knowledge and the intent, and her presence in the car was to help track, she's guilty. It's a fine line, and it's a tough line, and that's why everybody's fighting so much in that courtroom. So why this theory is powerful for the prosecution, I kind of just touched on this. Principal theory allows the state to charge everyone involved in a conspiracy with the same crime, even if their role is vastly different. That the shooter who pulls the trigger, the driver who provides the transportation, the lookout who kept watch, the person who tracked the victim's location, the person who provided weapons, the person who helped the plan, all can be charged with first-degree red rum as if they were the shooter. Why this theory is dangerous to the defendants? I just talked about that, because the act in furtherance bar is relatively low. defendants can be convicted of these serious crimes when their involvement is minimal. Like, for instance, in this case, knew her boyfriend and others planned to kill someone, intended for it to happen, and drove a car to track the victim's location. The key, though, is she has to have had an action independent that she did with the knowledge and with the intent. And that is why the defense believes this case is a weaker case, and this is why they're going so hard at it. She could be convicted of first-degree red rum as a principal, even if she never touched the weapon. So let's apply this. The state's theory: Andrews knew the co-defendant planned to kill Foolio. Texts say he needs to die. She's living in the house with the red rum weapons. She travels 200 miles to Tampa when Foolio's publicly announced location. Intent: she intends for it to occur. 2021 text: traveling with the shooters, coordinating via phone, and act in furtherance. If the jury finds any of the following: Andrews provided material assistance, and this is how they're saying she did, by driving and tracking the vehicle to Silver Cruz, providing her phone for coordination between vehicles. So she's providing the phone. In that act, it's small. But if they find that when she provided the phone to Chance for that purpose, that she knew the purpose was to kill Foolio and she intended for Foolio to die, she is guilty. Tracking Foolio's location at multiple venues. So if they find any of those text messages was sent or she provided any information with the intent for him to die, knowing he was going to die and knowing what the plan was, she is guilty. Acting as a lookout while shooters ambushed the victim. If she was there and that was her intent to do that, now the defense theory is following. Andrews didn't know about the red rum plot, thought it was a lover's weekend, no evidence she was told of the plan. Intent: Andrews had no intent for it to happen. She was in a bad relationship, we'll call it, and she was coerced and controlled by her boyfriend, and she just wanted a romantic trip. In other words, her presence is because she's being compelled to do these things because she is in a controlled relationship. Her act in furtherance: Andrew's actions were innocent. She drove the car because her boyfriend was asked to. She was a passenger, and she was a victim herself because she was dragged into this by her boyfriend. Phone use was a coincidence, and it was just simply more of because, again, you remove the intent, you remove the knowledge, and all she's there is there with a controlling boyfriend. That is the defense. Now, the judge limited the coercion defense greatly, and they said they can't present that. So that is going to be very difficult. The key battleground, the central question: when you look at all the evidence in totality, does it prove beyond a reasonable doubt that Andrews had actual knowledge of the plot, she intended for it to occur, and that she actually took an action to make it happen? Or is there reasonable doubt that she was the unwitting girlfriend caught up in her boyfriend's criminal conspiracy? Why the physical evidence doesn't matter, and this is because under principal theory, she doesn't need to have touched a weapon. She doesn't need to have left any DNA on any evidence. She doesn't even have to be physically present at the crime, nor have pulled the trigger. Now, as you know, due process is a major part of the analysis we take into account anytime we're looking at a case. Presumption of innocence. Does charging someone, and these are the questions you can ask yourself, does charging someone with red rum when they didn't kill anyone shift the burden of them to prove that they didn't know? Proportionality. Is it fair to punish someone with life in prison for driving a car when others did the actual killing? And proof beyond a reasonable doubt. Can circumstantial evidence, texts from years ago, presence at locations, phone records, really prove knowledge and intent beyond a reasonable doubt? That's the stuff we have to look at. So, how are you going to analyze this? When you're looking at the testimony, Andrew's knowledge, did she know it was planned? Intent, did she want it? Did she help it happen? And Andrew's actions, did she do something to further it? That's how you've got to look at this. That is the questions being asked of these jurors. Personally, I think the jurors going to probably find her guilty because of who she was consorting with and all the people she was around. And that's just, I don't think her courtroom presence was very good. I don't think she looks contrite at all. I don't think she looks very cocky and arrogant. I think the defense, you know, is putting on a strong defense. I mean, they're definitely aggressive. But I think that I think we'll see what happens. I think legally it's a difficult case. Am I convinced beyond a reasonable doubt by the evidence? I am not. Because if you're applying reasonable doubt and you're applying the presumption of innocence, then in my opinion, it still stands that she's possibly there for another reason. And if that's possible, if it's reasonable, it is to me that the state, without having someone there to testify about what she said, what she did, and who was involved, you can't eliminate that. And maybe someone on the jury will see that. I think at best we're going to be at a hung jury in this case, but we'll see. We'll see what happens. So that's where we stand, guys. I want to jump in and give you a little guide. If you're a member, you're going to have this in your folder. Go check it out. If not, I will attach this document as well inside this video, but you should already have this document if you're a member in your toolkit. Always be checking the toolkit throughout because things pop in there throughout the trial, and then sometimes they'll be officially released when I do a video like this. But if you're a member, you're getting them quicker and earlier, and you can go in there and check that folder, check your folder out, check the toolkit, and you see it in there. Anyways, with that said, guys, much appreciate all of you for watching and following along with us here and following the journey. Stay tuned. We'll be covering it tomorrow. We'll see what this jury does with this case. It'll be very, very interesting. Until we hear this jury verdict, guys, we'll be looking to continue talking about it and chat about it tomorrow as we're waiting. In the meantime, guys, let justice prevail, and I'll talk to you soon.